Okay, this is the second in a series of what we're going to be doing at Taylor English Duma, known as Quillian's Kernels. I'm Henry Quillian, and the general premise of this is to train paralegals, teach and train young associates, and also eventually to make this material available to the greater bar so that newly minted lawyers will have a practicum to go by with respect to litigation. The focus of this is the Civil Practice Act and the Uniform Superior Court rules and Uniform State Court rules, and those rules that impact your litigation through the courts of record, which for our purposes principally are the superior courts and the state courts that are denominated the state court of this county, state court of that county. So when I refer to the state court, I'm referring to the courts within the county that bear the name the state court. It can apply to probate courts as well. And what we want to do is we want to establish best practices and avoidance of malpractice, and also avoidance of what I call do-overs. In other words, get it right the first time so you don't have to wake up at night rolling in your bed whether something's been done right or not. And it makes the general practice of law a lot more easy and less worrisome if you just do it right the first time. And we have a fundamental rule in this class, which is when I say when in doubt, you say
read the rules.
Read the rules. And if I say if you're absolutely sure but have just some obscure memory as to why you're sure, what do you do? Read the rules. Okay. This is an interactive class, and the idea is for everybody to give input regarding their experiences regarding the subject matters we're discussing. And last time we had a hypothetical where we had Jane Smith suing John Doe on a note the day before the statute of limitations ran. We will change that subject matter a little bit in that we're not going to have a statute of limitations problem this time around. Let's say it's a year before the statute of limitations would run. We'll still have Jane Smith suing John Doe on a note. However, this time around, it's not really a note, it's just an agreement to repay or to purchase something. And a lot of those, the agreement is actually established by emails, some of which Jane Smith does not have because, as happens to clients seemingly all the time, her computer crashed. She knows there are emails that establish that there's an agreement between herself and John Doe, but she doesn't have them. She just knows they exist, but she needs to sue John Doe in order to get this money. And we'll further say that because there's no state, we'll start off with John Doe being in the state of Georgia. And we may change that as the time goes on because the focus of this session will be a continuation of the discussion of service of process. We started that last time talking about traditional service of process by sheriffs and process servers. And this one will go into non-usual service of process, such as waiver of summons, publication, out-of-state service of process, out-of-country service of process. It's not the intent to cover the whole entire spectrum of those, but we will touch on those subject matters. And then additionally, I want to discuss whether or not discovery should be served with the complaint. And so to sort of keep things in the order that you would do them if you were sitting in your law firm, let's discuss whether or not discovery should be served with the complaint. Does anybody have any ideas as to whether you can or cannot serve discovery with the complaint in a civil action under the Civil Practice Act? And if so, what kind of discovery can you serve?
Yes.
Okay, you can. Okay. And are you limited into what type of discovery you can serve?
I don't believe so. You can serve RPDs, RFAs, and interrogatories.
Okay, and so just to repeat, that's Ron Gaither for the record. And an RPD would be a request for production of documents.
Correct.
An RFA would be a request for admissions. and then interrogatories, can you serve notices of deposition?
Yes.
Okay, and why can you serve, and when can you set a deposition if you do serve notices of deposition?
After the answer should be filed?
Yes, it would definitely be after the answer would be filed. Now, let's discuss why you might want to attach discovery to the complaint. Are there any limitations in Georgia that you have with respect to the amount of time you have to do discovery in a case?
6 months.
6 months.
6 months.
Okay.
After the answer.
Okay, so it's 6 months after the answer that you have to do what? To serve discovery?
Complete discovery.
What's the basis of what rule are we talking about when we're talking about 6 months? Is that in the Civil Practice Act?
Superior Court.
Which Superior Court rule?
5 something.
Yeah. Well, and when in doubt,
Read the rules.
read the rules. So, do you have your rules? What Superior Court rule is it, Brittany?
I don't know.
Well, have you read the rules? I believe it is 5.1, which says, in order for a party to utilize the court's compulsory process to compel discovery, any desired discovery procedures must first be commenced promptly. So filing with complaint, serving with complaint would be promptly, right? Pursued diligently and completed without unnecessary delay and within 6 months after the filing of the answer. At any time, the court in its discretion may extend, reopen, or shorten the time to utilize the court's compulsory process to compel discovery. So what is the actual functional thing that we have to worry about with respect to getting discovery completed within 6 months?
The ability to have the court force you to actually do it.
That's right. So if you want to use the court to force the other side or a third party to give you discovery, then you have to have things in order for the court to do that within 6 months, which I believe I fairly interpret as meaning you need to be able to file your motion to compel before the expiration of the 6 months after the filing of the answer. People will disagree with that. I believe that's the most conservative and proper view, which means you have to do what as far as serving discovery as it relates to the expiration of the 6 months after the filing of the answer.
You've got to back it all up so that you've got time to have it be due and do a good faith attempt to get it, and then file your motion to compel all before the 6 months are up.
Okay, which in my book means serving the discovery on the other side at least 45 days before the expiration of the 6 months, so that you'll have your 33 days to get a response, and then you'll have time to evaluate it, do a good faith conference, and then file a motion to compel before the expiration of the 6 months.
Henry, that's certainly the most conservative approach, having researched and litigated that issue last year. The only reported authority is a Court of Appeal decision that says you can file your motion to compel after the 6 months.
Okay, so we won't identify for the record who said that, but we will talk about who rules the courtroom with respect to discovery.
And the message is in the scheduling order you get from the court, it ought to clarify when motions to compel are due, because you have judges who do not care what the courts of appeal say. They're going to do whatever they want to do.
And why can they do that?
Because they're the judge.
And because Uniform Superior Court Rule 5.1 says what?
But you'd think that the court would tell you in advance, as opposed to retroactively, the court's interpretation of the rule.
Yes, so is your general experience that state court and superior court judges do issue scheduling orders?
No.
My experience is the same. Generally, there's dead silence from the court until you ask them to do something for you. So Mickey's question may not be clarified in advance by the judge, so you better take the conservative approach and plan accordingly. That doesn't mean if you're down to 15 days before the close of the 6 month period that you just abandon asking the discovery, but it may mean that you have a worse argument down the road. Now that's a little bit far afield, but it's important when you're starting something that you know what your end game is. And so the end game would be completing discovery within 6 months. Is that a reason why you should serve discovery with your complaint?
Not necessarily.
Excuse me?
Not necessarily.
There could be a reason why not to. What would be a reason why not to serve discovery with your complaint?
You want to wait to see what they answer, see what positions they're taking before you formulate what discovery you're going to need.
That's right, because you've got a limited number of what to ask? Interrogatories. How many interrogatories can a party in a civil action and the Civil Practice Act ask? 50, including subparts. So you might not want to waste your interrogatories asking for something that you don't even have to prove because it's already been admitted in the answer, right? What would be another reason, strategic reason, why you wouldn't want to serve discovery with the complaint?
It gives an extra time, doesn't it?
It gives them 45 days to respond, but theoretically you want to get good responses, so maybe that extra time's good, maybe it's not. Somebody said cost. Who said cost? Chloe said cost. It costs a lot of money to draft decent discovery, especially tailored to the particular subject matter. Your client might not want to pay that much money up front because the defendant might just come up and say, hey, I'll settle this with you without discovery being served. Now, what would be some good reasons to serve the discovery other than getting a prompt start to discovery? Natalie? Why would you serve requests for admissions with a complaint?
So that you can, well, it depends on what admissions you're trying to get at. But in one particular case, an embezzlement case, I know somebody who served requests for admissions with the complaint, and they actually got what they wanted, although it was by mistake. And they said that the
We don't know if it was by mistake.
well, they said that they were entitled to $1 million, that the other side was entitled to $1 million in the request for admission, and then they tried to withdraw the admissions. But
So you might actually get admissions. If you serve requests for admissions, you might get it admitted what you ultimately need to prove in order to get what down the road? Summary judgment, which could put your case to a much quicker conclusion. Now, what happens if you get a defendant, you say it's Jane Smith, it's a suit for recovery of money. She puts in there, John Doe owes me $10,000. Well, the request for admission would be admit, Mr. John Doe, that you owe Jane Smith $10,000. And John Doe denies that in response to a request for admission.
You get costs associated with that denial.
Right. If Jane Smith down the road after trial proves that John Doe owed the $10,000, gets a judgment for it, what does Rule 36 say about who has to pay the attorney's fees for all that were expended in proving that money was due? And when in doubt, read the rules. And what rule do we read? 36. And what does Rule 36 say? It says that if somebody has been served a request for admission, has denied that request for admission, and it is later proved that that denial was without justification and was wrongful, and that the plaintiff, the person that's trying to prove that point, gets to recover the attorney's fees and costs associated with proving that which was denied. So all of a sudden, you have a grounds to recover attorney's fees, which you might not have otherwise. All right, now I mentioned that Jane Smith is bringing this lawsuit. She knows she owed the money, and she knows there are emails that she doesn't have that would help prove her case. Why would she want to serve request for production with her complaint?
Because the other side has those emails as well.
That's right. You can get the emails to prove the case that you know you have, but you don't have the documents to prove. So that's a good reason to serve document production, request for production of documents with your complaint. How many requests for production can you serve?
Unlimited.
You can can serve an unlimited number so long as it's not so many the judge thinks you're crazy and being abusive, right? But you don't have to worry about counting them one by one if you need to have a larger number of requests for production down the road. You're not burning off your limit by serving them with the complaint. Yes?
Can I go back on the commencement of the discovery period?
Yes.
You've got multiple defendants. Is it the last answer or the first answer that begins in 6 months?
Yes. All right, the question is, under Rule 5, Uniform Superior Court Rule 5.1, is it the first answer or the last answer that sets the time period during which you can, as the plaintiff, pursue and use the compulsory processes of the court to get discovery responded to? I don't actually know. That's something that's boggled my mind all along. So what I do is, one, set it as the first answer, and then two, try to get the parties to agree to additional, to come to a consensus as to when discovery is going to conclude. Has anybody ever litigated that issue and gotten a ruling on it? Okay, so the answer is, among all these people here, we don't know the answer, and that's because I don't think it's clear. But what I do think is, and that's the point I was getting to earlier, under Rule 5.1, the court in its discretion may extend, reopen, or shorten the time to utilize the court's compulsory processes. So I think you want to play within the rules if you can, and if you think you're going to be outside the 6 months, you can ask the court for additional time to get response to a particular discovery or whatever. Try to protect yourself for the record and also to actually get the discovery. Okay. With respect to interrogatories, what would you want to ask no matter what in every case?
Seems like the first one I always read is who assisted in the preparation of these interrogatories.
Okay, and why would you ask that?
I always ask. That's going to be my first deposition witness.
Okay, so if you are asking a respondent to say who prepared the interrogatories responses, that person theoretically will have signed the what?
Verification.
The verification. So you can then use those interrogatories as for cross-examination in a deposition, and it might give you an idea of who knows most about the subject matter. What other things would you always want to ask in virtually every case in interrogatories?
Who are the witnesses?
Yeah, who knows about this subject matter? Why is that? Why do you want to know who the witnesses are?
Review them, depose them, ask them for documents.
All right, so we got interview, depose them, ask them for documents. They might be a non-party person who knows about it, and you might have to do non-party discovery on those people. And you don't want to be blindsided at trial, right, with somebody that shows up that testifies all about your subject matter when you didn't even know they existed as a witness. So would you just ask, name all witnesses? Would a better way to ask it be, please identify all people who have personal knowledge of the events and circumstances laid out in the complaint? Or you could be even more narrow and say the subject matter. I believe that's an interrogatory that no judge at the end of the day is ever going to say that you can't ask it, that it's overly broad or not discoverable, because everybody knows they have the right to find out in discovery who it is that knows about the disputes at hand. Okay, any other interrogatories that you would always want to ask in any case, so why not ask them up front?
Anything relating to expert witnesses you might be calling?
That's right. Rule 26 expressly, 911-26, expressly allows you to get certain information regarding the opposing expert witnesses that the other side expects to introduce evidence with at trial. And why would you not want to ask that early on?
You're entitled to it anyway.
You're entitled to it anyway, but what I have found is people forget to go back and ask. So if you put the Rule 26 expert interrogatory in your first set of interrogatories, then one, you're not going to forget about it, and two, they have a duty if they come up with an expert later on to do what with respect to that interrogatory. So if you get to the pretrial order and they list a whole bunch of people they intend to introduce as experts in the pretrial order and they've never supplemented their interrogatory responses, then you can possibly knock those experts out. And 91126 sets forth what you definitely can ask, and even if the other side objects, you can go straight to the rule to show the judge that you have the right to get that person's discovery. And let's see if we can locate that. Does anybody know the exact location of the expert interrogatory rule? Here we go, 91126A4. A party may, through interrogatories, require any other party to identify each person whom the other party expects to call as an expert witness at trial, to state the subject matter on which the expert is expected to testify, and to state the substance of the facts and opinions to which the expert is expected to testify, and a summary of the grounds of each opinion, for each opinion. So Rule 26 gives you the right to ask that, and it's one that if you forget to ask it, you might find your pants down when you get to trial. So you want to go, I like to go ahead and ask that one up front, get it over with, and that puts a duty on the other side to supplement when they finally get their experts. Now, does that mean that you can ask in that interrogatory, identify every document that the expert looked at in order to come up with his or her opinion?
No.
It doesn't state that. So if you put that in your interrogatory, you might draw an objection and it might be enforced against you by a judge. But if you stick with the rule, the judge doesn't really have much discretion in deciding whether he has to compel an answer from the opposing side. What else might be a good one to ask in your first set of interrogatories? You got your witnesses, you got who prepared the interrogatory responses, you got your expert witness testimony. These are four you're going to use, or three there you're going to use no matter what of your 50.
Factual basis for the claims?
Yeah, or the defenses if you're serving the defendant. So you could state something like, if you raise any affirmative defenses in your answer, provide the facts that you contend support the defenses you have asserted. Now, what does that tend to do with respect to the defendant? If the lawyer is handed a complaint and a set of interrogatories that they have to respond to sometime after getting them served on them, since we haven't discussed that yet, what will that tend to cause the opposing lawyer and client to do?
Choose their affirmative defenses carefully.
Yeah, it might limit the affirmative defenses that they actually assert, so it could winnow down the amount of things you have to worry about. It causes them to do what? Also, in order to figure that out.
Investigate.
Excuse me?
Investigate.
And yeah, to investigate their case and analyze it, see whether they actually have a defense. And so you've got to use a strategy on this. If you're going to, sometimes I want to depose the opposing party straight out of the box and give them no reason to do any preparation with their lawyer beforehand. Why is that? Because I know some people on the other side are going to lie, or that I'll have great materials to cross-examine them with. So I will just serve request for production, request for admissions, maybe, maybe not, and notice of deposition. So I get them under deposition lying in untenable positions before I have them sit down with their lawyer and go through the grueling task of answering interrogatories. So it sort of depends on what kind of case you have and what you're trying to accomplish from a litigation standpoint as to whether you serve that interrogatory, which causes the other side to go through a grueling investigation and evaluation of their defenses.
Henry, do you think it's used as a scare tactic to serve, to serve discovery up front to kind of make the other side feel like, well, I'm going to make you spend a lot of money. I'm going to be very on top of this case early on?
I believe it is a psychological advantage to what I call front load your case so that you're going to get as much, so it's very clear to the other side that we're going to push this case through and prepare for trial, and if you don't settle, we're going to get a judgment against you. So, and also there's economic issues that come into that for the other side. If it's a $10,000 case, hopefully we're not bringing too many of those, but if it is, they may make the decision, I'd rather pay $8,000 and not pay my attorney $4,000 to answer the discovery and go ahead and be done with it in the settlement, as opposed to pushing it all the way through, going through all the steps. Okay. Rule 26 provides another interrogatory that you most positively can ask without any valid objection. What would that be?
Is it insurance?
The answer is yes, you can ask an insurance coverage interrogatory if you draft it correctly, asking, provide and identify any insurance coverage that there may be for the defendant in this case. But that's not the Rule 26 one that I was focusing on, and I'm not positive that it's within Rule 26 that interrogatory is. The grounds for that interrogatory is. There's one that says you can ask the other side to identify any statements made by the plaintiff, if you're representing the plaintiff, which you are in this instance. Make any statements made that you have that are made by the plaintiff regarding the subject matter of this litigation. There could be some debate over what a statement is, but let's say a letter was written by Jane Smith to John Doe saying, I know you owe me this money, but you're having a hard time, so I'm forgiving you the debt. It's statements like that would be very, very helpful to know as a litigator up front, especially if you got the case on a contingency fee, before you go all the way through and then find out at trial that your client issued this statement. So the general idea is find out, in this instance, is find out what you can about your case for what's in an interrogatory you're going to ask no matter what early on in the case. All right, so let's assume for the moment that Jane Smith elects, for all these different reasons, to serve discovery with her complaint. How long would the defendant have to respond to the discovery?
45 days.
45 days from when? All right, and if it's 45 days from service, that would be service of process with the complaint and the discovery. Okay, and if service of process was made with the complaint and the discovery, what would you want to make sure your certificate, your affidavit of service has in it when you file it with the court?
That you served discovery.
Would you say, I served discovery, or would you list the individual items of discovery? Okay, so because you're not going to put a regular discovery certificate of service on the back of this discovery, are you?
No.
Because as a lawyer, you're not serving it, and there's no means to serve it by mail on the opposing party anyway. You're going to have your process server say, we served X, Y, and Z. So what happens if you want to use a sheriff for service of process and the discovery?
Make sure you write it on the sheriff's entry.
Right. The sheriff's entry of service form will not have a spot for all this discovery. However, you can cram it in there with a typewriter or very neatly handwritten, so that when the sheriff files his entry of service with the court, it will show the discovery that was served with the complaint. All right, let's assume for the moment defendant answers the complaint but doesn't answer the request for admissions, and the request for admissions include everything that was in the complaint. What advantage could that provide?
You've admitted them.
Under what rule would the defendant have admitted those requests without ever having done anything in response to them?
Is it
36?
36?
All right, 91136 provides that if the receiving party of a served set of requests for admissions, if they don't respond within the time allowed by law, they're deemed to have admitted the facts that are contained within their request for admissions. And do requests for admissions only apply to facts, or can they be broader requests?
They can be broader.
They can be broader. They can include the application of law to fact, right? And so, for instance, Jane Smith could put in there, John Doe owes me $10,000. It might be very wise for Jane Doe to put in there, I gave John Doe $10,000 in cash. He promised to pay it back in separate request for admissions. He promised to pay it back. He hasn't paid it back. And then put as a conclusion, John Doe owes Jane Smith $10,000. But a request for admission, something like John Doe owes Jane Smith $10,000, is an application of law to fact. And so you could move for summary judgment if John Doe failed to respond to the request for admission. Or if John Doe was honest and admitted that one, then you can move for summary judgment on that. Shorten up your litigation. Okay, so we've talked about the service of the discovery, and we've talked about when the discovery has to be responded to. Yes?
Are requests to admit considered discovery that have to be completed within 6 months? Because I've seen it both ways.
Okay, so the question is, under 91136, our request for admissions discovery that has to be completed such that it is served and answered within the 6 months after the filing of the answer. Does anybody have an input on that? Well, do you have to use the court's compulsory processes to get an answer to request for admission?
Our request to admit covered by 91137, which deals with efforts to enforce discovery requests. Because the provision that allows you to recover your attorney's fees, if you have to prove a request to admit, is in 91137.
Right.
Right, which generally covers discovery. So, I mean, I would start there saying it's recognized as part of discovery in 91137.
Okay, so the proposal here, just in case the camera didn't hear it, is the 91137, which relates to enforcing discovery and the sanctions associated with failure to respond, covers requests for admissions. And it provides the means by which you can get the recovery of attorney's fees, right? And also it provides a mechanism by which you could, I think you can attack the adequacy of the response to the request for admissions. But does that mean that you have to use the compulsory processes of the court to get a response?
Well, not to get a response, but if you're going to question the adequacy, I would think that would be a motion to compel.
All right, so that might be limited by the discovery period, the attack on the adequacy of the responses to the request for admission. But since I would take the position, and I think it makes sense, that since there is a default in there that if you don't respond to requests for admissions, they're deemed to be admitted, then you don't have to use the compulsory processes of the court to get an answer. That's not to say that a lot of people will not nevertheless object to responding to requests for admissions. But if they just object and don't answer, an objection is generally not an adequate response under Rule 36, then you could say that you could do it outside of the discovery period. And the other reason for that is a lot of times requests for admissions are used to authenticate documents before trial. And so it makes sense that you might be able to do that outside the discovery period. But I think the ultimate answer is, what does the judge do with the request for admissions that fall under the situation where they would have had been responded to outside the discovery period? However, I definitely don't say ignore requests for admissions if they're served outside the discovery period. At a very minimum, object to them and say you don't have to respond. I don't know if that's a safe course of action, however. Okay, so we've got to get on to the service of process by alternative means. What's the easiest way and least expensive, cheap way to serve process under the Civil Practice Act?
Waiver of service.
Waiver of service. And what rule is that under?
911-4 or something. I don't know.
There we go, 911-4. And can somebody generally describe the mechanism that they have for waiver of service in the Civil Practice Act? Well, there's a setup in there that's intended to, I'm not sure if at the end of the day it really helps very much, intended to reduce the cost of actually bringing about service of process. One reason why I say that, it takes attorney time to put all the papers together in order to do that, and by the time you do that, you might spend more money on attorney's fees than you would at paying a process server. But it basically, 911-4E, I believe it is, sets up a mechanism by which you can mail a request for waiver of service to the defendant along with a copy of the complaint and ask them, hey, you basically tell them you have a duty to try to avoid running up expenses in this litigation. And if you respond to this request for a waiver by signing a form document that they lay out in 911-4L, then you can, one, avoid the cost of having to serve the complaint on you, and then two, you have more time to respond than you would otherwise. For somebody within the state of Georgia who is not a federal government entity, I guess, I think it's just for somebody within the state of Georgia under the Georgia rules. So now, has anybody actually read through carefully the legislature's setup of this rule? Despite the fact that I repeatedly asked you to. Well, there are quandaries that come up under this rule, in my view, which I'll bring to your attention because they could be significant. First of all, what's the penalty if you're the defendant and you don't waive service? What's the penalty?
You have to pay the cost.
Okay. Of what?
Service.
Of service. So if the sheriff charges $25 to serve the complaint on you, you have to pay $25 at some point. I'm not exactly sure when that is. I think it's upon motion by the plaintiff. So am I going to spend a lot of time moving to get $25 back? Not early in the case. Maybe after I get mad for a while. But the way this is set up is you send this set of documents, and the forms are set out in the rules, and you tell this defendant you have this opportunity to do this. And if they do send back the waiver, what are they waiving? Are they waiving service?
The defense of improper service.
Well, that would be one thing they're waiving. What functional aspect we talked about last time are they waiving? What paper doesn't have to be served with the complaint?
Summons.
The summons. Exactly the theory behind all that, I'm not sure, but a waiver of summons means that there doesn't have to be a summons. And I guess there's no need for a summons to order the defendant to answer if the defendant has signed this form that says, I will answer within this period of time in order to avoid having to pay costs. Now, so the defendant has to respond within 30 days by sending in the form that says, I will waive summons. And then they have how long to answer?
60 days?
60 days from what?
From the day that they put on the form, the day that the plaintiff puts on the form.
The date the plaintiff puts on the form.
Right. The plaintiffs send you.
Okay. So the argument is that's been proposed here is that the defendant has 60 days from the date the plaintiff put on the form sent to the defendant asking the defendant to waive service.
Yes.
All right. Where's the rule on that?
9/11.
When in doubt,
Read the rules.
okay. Well, we've already talked about the fact that it was 9/11. 9/11-4. Let's see, it'd be B5, I guess. And it says, a defendant that before being served with the process, so if you get served anyway, you can't waive it thereafter, right? If the plaintiff gets anxious. Returns a waiver so requested in a timely manner is not required to serve an answer to the complaint until 60 days after the date on which the request for waiver of service was sent, or 90 days after that date if the defendant was addressed outside the judicial district of the United States. Okay, so you're right as far as that part of the rule. Now, if you are a defendant and you get the forms that are sent to you as set forth in the code, listen to this language. This is on the waiver of summons form. They actually call it waiver of service of summons form that would be in the package that the plaintiff would send to the defendant. Okay? This is the last paragraph of that form that the defendant would sign. I understand that a judgment may be entered against me or the entity on whose behalf I'm acting if an answer is not served upon you, meaning the plaintiff's attorney, within 60 days after the date of this waiver, the date this waiver was sent, or within 90 days after that date if the request for waiver was sent outside the United States. I read that again. The name of this form is Waiver of Service of Summons. And it says, I understand that a judgment may be entered against me or the entity on whose behalf I am acting if an answer is not served upon you within 60 days after the date this waiver was sent. So which one is it? 60 days after the defendant serves the waiver, or 60 days after the plaintiff sends the request for a waiver of service?
60 days after the plaintiff sends the request for waiver of service.
Okay. Why?
Well, that's what the rule says.
Right.
But the form says the opposite. It says the date after this waiver was sent. It's not a waiver until the defendant waives it, right?
Waiver form.
Waiver form. Poorly worded.
Yes. Waiver form is wrong in my view, but I bet it could trip up a lot of defendants if they sit there and read it, because it says after this waiver was sent. Well, it's not a waiver until it's a waiver. And so that was one of the messed up things that I found within here. So if you're representing a defendant, what do?
Go by the rule.
Go by the rule, because one is a statute and one is a form within the statute, right? And the one that's actually the binding law is the one that sets forth what the rule is. Okay.
Well, as a practical matter, if you're the defendant's counsel, you say to the plaintiff, we'll agree to waive service if we can agree on a date certain as to when our response is due. So you buy yourself some additional time that way.
Okay, so we've got a proposal here. Defendant's lawyer calls up plaintiff's lawyer, and you decide on a date certain. If you do that, does the plaintiff have to serve the summons? Because it's not going to be directly in accordance with this rule.
Well, the way you do it is you agree that the waiver form will be deemed to have been sent as of date X, which means that the response is due 60 days from that date.
Okay. Okay, so how can you change the date the waiver form was sent?
By agreement.
Okay, just by agreement. Now, what if you do this? What if you're the defense attorney, you get this, and you call up and say, I'm going to acknowledge service of process. and let's don't worry about the hogwash that's in the Georgia legislature forms. I'll acknowledge service of process, and you sign a document that says, let's say it's 3 days after the plaintiff has mailed this thing, and it says, on behalf of John Doe, I hereby acknowledge service of process of the complaint and summons. Sign it, send it back. When do you answer?
30 days.
30 days after your acknowledgement, right? And now, what about this? What if you, in your acknowledgement, you say, I'll acknowledge I got a copy of the complaint, sign it and send it back, and there's no summons, because remember, no summons with the waiver of summons.
That won't work. I mean, that won't start the time.
Will it even start the lawsuit?
No.
So if you're the plaintiff, you have to be careful about that, because you might not actually have a pending lawsuit against the defendant, right? If there's been no summons issued and all they did was acknowledge getting a copy of the complaint.
I'm sorry, doesn't the filing of the complaint start the lawsuit?
Well, we talked about that last time. It starts the civil action, but does it provide personal jurisdiction over the defendant?
No.
No, not without a service of the summons or a waiver of summons. So if you're a really, really slick defense attorney and your client has no defenses, you theoretically might try to pull that off by saying, I acknowledge service of the complaint, but don't mention anything about the summons. And there's actually a case where apparently that happened, where it was an attorney being sued. I'm not saying he was slick, but he did only acknowledge receipt of the complaint, did not acknowledge receipt of the summons. Judgment was entered against him on a note. He appealed it, and this took years and years and years. And then the judgment was reversed, so the plaintiff had to start all over again because the court held, and that's the Stamps versus Bell South case that I mentioned last time. The court held there was no personal jurisdiction over the defendant this entire period of time. Okay, so let's assume that you send out your process server, private process server, best person PI in the world. The person looks high and low at every address that you had for the defendant, and the person is not to be found. They ask all the relatives. None of the relatives know where this person is, who is the defendant, John Doe. What other means might you have of serving the complaint?
Notice of publication.
Excuse me?
Notice of publication.
Okay, publication. What rule is that under?
911.
911-4, yes. 911-4F, subsection C. And it is a long process, but essentially you have to ask the court using an affidavit that sets forth all the information you have regarding the defendant, what their last known address was, what your efforts were to serve them, that you've been unsuccessful, and that you ought to have the right to serve the complaint by publication. Now, what is publication?
Ad in newspaper.
So you can't just put it on the internet, like launch a website that says John Doe lawsuit and put it on the internet. John Doe has been sued.
It has to be something readily available to the public.
It's usually the paper that's in that county, the judicial paper.
Like the sheriff.
You're suing the defendant.
Yeah.
Every county has a legal organ, right? Lawyer lingo. And is that since it's lawyer lingo, is that a heart, a brain, or a muscle? What organ is it? And so you follow the process, which we won't go through in minute detail, but you follow the process 911-4FC, making sure your affidavits are adequate to induce the court to provide a order allowing the case to be served by publication. And then the clerk of the court has to make sure that the publication notice is put in the legal organ a number of times, and I don't know exactly how many, over a period of 60 days. Has anybody ever served by publication? We got two over here. In what circumstances was that?
It was a breach on a promissory note for one of the creditors that we represent. We could not find, well, we could locate the defendant. However, he lived behind an extraordinarily large gate, and the process server couldn't get on the other side of it, and you could never catch him coming in or out of this gate. And so finally, our process server, who's really good at answering threats, said, I just can't get to this guy. And so we moved for an order for the judge's comp superior who issued it, and we served via publication.
Why didn't the process server just use her Humvee and knock down the gate and go serve him?
I don't know, but I should ask her that now.
There are bounds by the process servers cannot use any means that they desire in order to get to the defendant.
That's not any means necessary.
Well, maybe they could have used a rocket-propelled process or something to deliver the process. Okay. What about if you need to serve somebody out of the state of Georgia, but who, let's say there's no, in this instance, John Doe's lived in Georgia all the time up until the time he knows he's about to get sued and he moves to California. What would you need to do in order to serve process on John Doe in California? Assume you know where he is.
Secretary of State.
What does John Doe have to do with the Secretary of State? Nothing, really.
No.
John Doe's not a corporation. So we might run through that scenario, though, where John Doe is the registered agent for a corporation. But so John Doe needs to be served. You can get a private process server, right? Well, who can you sign up a Georgia private process server and then have them give it to their buddy in California and have it served?
No.
If you wanted to get a private process server to serve John Doe in California, who would you have to get?
Someone in usually within the county that you're trying to serve this person, regardless of where they're located. And actually, I would try the sheriff there first, and then the process server if the sheriff can't get them, just to have good proof of service.
Okay, so Diana proposes that first stage would be utilizing somebody, the rough equivalent of a Georgia sheriff. It might be called something else in the foreign state to serve the process. Do you have to get an order from the Georgia court in order to have a California sheriff serve John Doe in California? The answer is no. Do you have to use, which return of service forms or entry of service forms do you use if you have John Doe served by the sheriff in California?
California.
Okay. I think it's generally California's return of service forms. It's got to be something that looks official, otherwise the Georgia court might not buy it, right?
Yeah, and it has to be certified just like the sheriff would do it here.
Okay, so you mean he has to inscribe the return of service saying who he is and what he did, correct? If this, would you typically have to pay a fee to the sheriff in California in order to get this accomplished?
Yeah.
Okay. And I don't know whether or not in the foreign jurisdiction they will also serve, allow you to serve discovery along with your process, but you would need to check that in advance, and then if you were going to serve discovery. And additionally, what kind of complaint do you have to use in order to serve a defendant in a foreign state?
Second original.
All right, a second original. We talked about this last time. What is a second original complaint?
Just to copy the original, say second original.
Okay, Diana has answered this. It's a copy of the complaint that has either handwritten or stamped the words second original. Not a whole lot of magic to it. Why it exists, I have no idea. But somewhere along the way, it was used, I think, to keep track of papers that were from another county versus the home county. And also, I think, would help a sheriff who was out riding around in his car. If he's in DeKalb County and he sees a complaint from Fulton County, he doesn't know whether they put the wrong county on the complaint or whether he's serving on behalf of another county. It helps him to get the complaint back to the right spot. Just give him the return of service back to the right county. Okay. If a John Doe leaves the country, but we know where he is. He's gone up to Canada. How do we serve him with the complaint? Excuse me?
I said that's always fun.
Oh, we have fun. If it's in a really good place and it's somebody else's law firm, they sign me up as the process server and hire me to go do it, and then I spend the weekend there. Can you serve somebody in a foreign country with a designated process server under the order of a Georgia court with process? Any consensus on this? Diana's saying no. I don't know for sure. I don't think so. I think you have to go under the Hague Convention for Service Abroad of Extrajudicial Documents. I think the name of it is. And does anybody know about that procedure?
A little bit.
Okay.
Sorry, I'm
yeah.
a BP case. What can I
Yes.
say?
Oh yeah, the BP case.
They have to be served overseas.
Okay, basically there is the Hague Convention. You can read it. It's got forms. You have to identify something called the central authority in the foreign country, which is something like a sheriff's department. Let's say it's in Alberta, Canada. You have to find the rough equivalent of the sheriff's department or the Secretary of State or somebody they designate as being the central authority for service of process. And the first thing you have to do is make sure the country you're serving in agreed to the Hague Convention. Because if they didn't, you have to use what procedure? If they didn't agree, you have to use the procedure for serving letters rogatory in that state. And so we'll have to go into that, and we won't go into that. It's too much. But basically, you have to determine if you're going to use the Hague Convention whether the country you're going to serve in is a signator to the Hague Convention, and then you have to fill out the forms, get in touch with the people that are at the central authority, ask them what they're going to want from you, which theoretically will be the Hague forms filled out, and then you send them the information, whatever check they need, and ask them to serve it, and then you have to, of course, get the proof of service back from them, right? Mm-hmm. And hopefully you're in a reliable country where they have some credible means of getting proof of service back. What if you're suing just over the status of real property and not trying to get an actual judgment against a person or a corporation as part of your lawsuit?
You can tack and mail.
Can you tack and mail? Is that what you said? Well, let's run on this. What is tack and mail?
It's when you post it to the door in a certain way, in a certain package, so they can see it, and then you mail it to them on the same day. But it has to be like, I think, priority mail or something like that. Tack and mail.
The answer is, I don't know if you can do that if you're suing somebody over their interest in real property. Mm-hmm. And that is it. What I do know is if the suit is for less than $200, you can do that. If it's seeking a money judgment for less than $200. Because that is in where? The rules. But with respect to the property issue, I know that 911 4F1B says you can ask for an order from the court for service by publication, which I would probably use that, and that's only after due diligence in attempting to serve the person with process under the ordinary course of things. Okay. The one other thing, that's pretty much covered, service of process. The general point is you have to follow the rules, and because that's sort of the foundation of your lawsuit. You want to make sure you get it started right so you don't have to do a do-over. And you certainly don't want to show up in court and have your knees cut out from under you by the other side successfully contending that you didn't serve them. And if you get an answer that raises service of process as an affirmative defense, look for two different things. One is insufficiency of service of process. What does that go to?
Service.
It goes to service. It goes to all the things we just talked about. If they raise that, you better pin down what it is that you did wrong or what they claim you did wrong so you can fix it. Because if you don't have a statute of limitations problem, you almost always can fix service of process. And then what if it says there is insufficient process?
The form's wrong. There's something wrong with the form.
That's right. You didn't serve a summons, or you named the defendant incorrectly, or you didn't have the complaint attached to the summons, or something like that. So you need to drill down on what that problem is too, because those are valuable and relevant defenses. Make sure you follow up promptly and get your proof of service of record. How long do you have to do that? I believe you have 30 days after service to get your return of service filed of record. And that would be, I believe that's, let's see, if the proof of service is not filed within 5 days, the time for the party to serve to answer, the process shall not begin to run until the proof of service is filed. That's certainly a significant rule to note, which is 911F. Excuse me, 911H. So take a look at that. You ought to get it served. You ought to get it filed promptly after obtaining it. And if you end up, and before you move for a default judgment, you might want to check to make sure that they don't have any extra time to answer. One other thing I wanted to mention very quickly on suits of and it goes right along the lines of service of process. Service of discovery with the complaint is if you're suing for an action on open account, you can verify your complaint under 910.112. And what is a verification? Anybody?
Swearing that the facts of the complaint are true.
Okay, swearing the facts in the complaint are true, which in this case, if it's the case on open account, you're swearing that the amount shown in the complaint is the amount of the account and that it's an accurate accounting for the amount of money owed. If you verify the complaint on a suit of open account, well, if you verify any complaint, what does the defendant have to do?
Verify the answer.
Verify the answer, which means they can't fudge maybe to the same extent that they would otherwise, right? Because they have to swear that it's true. Lots of times defendants just deny everything. In fact, I often put in the 2-word paragraph allegation in my complaint, time passed. T-I-M-E space P-A-S-S-E-D. If they deny it, then you know they're just denying everything, because time always passes. But they often do deny it. So. But if you verify the complaint on a suit of open account, the defendant is forced to do something. Let me read this to you. 910.112. Whenever an action is brought on an open account and the same is verified by the plaintiff as provided by law, the answer either shall deny the defendant is indebted in any sum or shall specify the amount in which the defendant admits he may be indebted, and it shall be verified as required by law. So, if you're trying to collect a debt, that puts a major squeeze on the defendant, because either they have to come up and say, either I never entered into this account, or there's some defect in the underlying contract under which you're claiming that you're entitled to recover, like an illegal contract. Maybe it's to sue on a debt arising out of gambling or something. Or they have to say how much is owed. And if they just generally deny it, you can move to strike the answer as being inadequate. And a judge should force them to comply with this statute which if they did, you then move for judgment on the pleadings and get your judgment quicker. All of our clients like to get their judgments quickly and to collect quickly if they're the plaintiff. If they're the defendant, it's just the opposite. Okay, that covers it for the day. Thank you very much for your participation. And we will be back next month, third Thursday of every month.